Hello. We have a visitor, Vice Chancellor Samuel Glasscock, Vice Chancellor of the Court of Chancery of the state of Delaware, visiting the Markkula Center for Applied Ethics at Santa Clara University. Vice Chancellor, thank you for being here.
It's a very great pleasure to be here. Thank you.
Vice Chancellor, what are the 2 or 3 areas that have dominated the court's agenda over the last couple of years?
All right. Well, let me say first that that is a difficult question to answer for a procedural reason. And that is, we're a common law court, so we don't seek out issues. We don't say, gee, that looks like something needs to be opined upon. We're limited to the cases that come directly before us and the facts in those particular cases. But let me tell you a couple of areas that we've seen quite a bit of over the last year and a half that I've been on the bench, because I've only been on the bench a short time, and that I think may continue. One has to do with compensation for corporate executives and corporate boards. It's an issue that doesn't occupy a lot of the capital of the company. These are small board decisions looked at given the capitalization of any particular corporation typically. But they're very important from a public relations standpoint. People were very understandably upset in the last recession at the bonuses and compensation taken by executives in corporations that were failing, in an economy that was failing. And the political question that arises, what do you do about it? We got the safer pay rules, several different reactions from state legislatures as well as the federal government. We are also faced with those issues and have been repeatedly. Now, typically, those issues are considered quintessential board functions. How much to pay an executive? Because, frankly, no one has elected me to a board of directors. I'm not suited to it either by temperament or by training. I don't think I'm alone among judges in that. And I should not be making decisions, corporate core decisions, such as how much do the employees get paid. The exception to that is obviously when there is a conflict of interest between the board setting those salaries and bonuses and the employees who are receiving them. And that could come in a variety of ways. I mean, an obvious way is the board setting its own salary. That obviously raises concerns. But there are much more subtle problems that we have to deal with, such as the relationship, and it may be a social relationship, it may be an outside business relationship, between typically the CEO and the board of directors. And what weight to give those influences on the board in determining whether the board is truly independent. So those issues, I think, are both publicly watched. It's one of the few areas of corporate law that the general public has an interest in, and we're also seeing them repeatedly, and I've had a number of them already in the past year and a half.
Is there a second issue that comes before you frequently these days?
There's another issue that I think may be worth talking about, because we have seen several of them, and it's an interesting issue to me. And it's something that, being here in the Valley, I see more of coming out of the West Coast than the East Coast. But it involves 2 different classes of common stock. And a CEO, a founder who takes his company private, sells stock to the corporation, now there are fiduciary duties owed to the corporate stockholders, but he or she retains control by use of holding a class of common stock that has extra voting rights. What are the responsibilities then of that corporate controller to the stockholders who don't have those rights? And it particularly comes into play when there's a change in control. And what kind of control premium can be taken by that holder of the corporate interest, the corporate control, even though the majority of the stock has been transferred to stockholders. So we get those kind of conflict issues, and they could arise in a variety of ways. And one of them I recently saw involved a corporation where the charter prohibited the controlling stockholder from receiving a control premium by saying that in a change of control, the shares of this super voting stock would be converted into 1 share of common stock. The problem was there was a large offer above market. He wanted a control premium. He told the board he would not allow it because he had the control, unless the stockholders voted to accept it and a change in the charter that would allow him to receive it. So that was the question before me. That's the kind of way it comes up.
Besides these two issues, can you give us a sense, looking over the horizon, are there other issues that you expect to have arise over the next 2 to 3 years?
You know, that question, I think, is probably not one that I can answer very well, because as I've said previously, as a common law judge, I get those questions that come to me. We see each judge, while we have a broader interest in the law, obviously, in our cases, we're looking through a pipe, and we see a little bit at the end of the pipe that we're really dealing with. So for me as a common law judge to try to guess that, I think would be unproductive, except in this way. Whenever there is a recession or hard times, there is political pressure put on Congress to act to protect individuals. It's kind of a one-way ratchet, and we see more and more federalization of the law. Now, obviously, it sounds self-serving for a Delaware judge who wouldn't have it. I mean, I'd be picking peaches or something if it weren't for the fact that there's a state common law of corporations. But I do worry that a lot of issues that could be decided incrementally in the common law form, where there is a decision, it's the smallest possible decision, it gets reviewed by all the corporate actors and all the people who are stakeholders in the corporation. They respond in their actions in a way that puts a little twist on that. It comes back to us, and the common law grows organically. That is so much, it seems to me, more efficient than the blunt tool of federal legislation, and I'm sure anyone who is listening to this would know that there are many examples of laws that were well intended that may have had good results, but also had unintended bad results. And it's easy to change a judicial decision if it's a bad one. That's what we've got a Supreme Court for. A Delaware Supreme Court's not shy about doing that, and they shouldn't be. But it's very difficult to change legislation passed by Congress, particularly where it's popular. You know, whether it's a populist appeal of limiting actions of corporate actors. So I'm concerned about that. I'm concerned about the increasing federalization of what has been the state common law of corporations.
But you wouldn't be surprised to see say on pay and the question of two classes of stock continue to be prominent.
I wouldn't be surprised to see those be prominent, nor would I be surprised to see further legislative intervention into those areas.
Vice Chancellor Glasscock, thank you for sharing with us your thoughts on the issues that have come before the Delaware Court of Chancery and what we may look for in the years ahead. There are more materials, videos, articles on corporate governance available on the website of the Markkula Center for Applied Ethics at Santa Clara University. Thank you.